Let's now get into that discussion. Joining me in studio in my extreme left, Nelson Harvey. He is a lawyer as well as Washington Makodingo, a governance expert and political analyst. Thank you very much, gentlemen, for coming in. I'll start with you, Nelson. What do you make out of that, really?
It was not my expectation that the Court of Appeal will side with the High Court, but having listened to the entire decision by the Court of Appeal, it sounds quite well-reasoned and justiciable. It's now quite clear that the IEBC will have to complete the contract that they had with Al Ghurair, print the presidential ballot papers, and undertake the exercise that it's required to undertake come the 8th of August to ensure that we have an election within time.
Well, was it not your expectation that the appellate court would side with the High Court?
Look, from the beginning, the case by NASA, the manner in which it was framed before the High Court, did not really indicate any high prospects of success. In fact, to many lawyers it came as a big surprise that the High Court ruled in favor of NASA at the beginning. But I think there are many other reasons that could have necessitated the decision of the High Court to a large extent a wider and interpretive review of the Constitution as well as the public interest. But when it came to the Court of Appeal, and it must be understood, the mere fact that a decision of the High Court has been set aside by the Court of Appeal does not infer impropriety or lack of proper knowledge by the judges who made the decision. Because, look, the most important consideration that the Court of Appeal took into account was a reading into the statute and the regulation that there is a time frame within which you must procure, and they reduced that time frame to a maximum of 30 days and to a minimum of 14 days. And if you look at it to that extent and that extent only, the only explanation that the Court of Appeal could have relied upon substantially to come to this conclusion was the need to ensure that there is no limbo, there is no lacuna come the 8th. But that does not, in my view, put aside the initial concern by a greater population of the Kenyan public that the entire contract was shrouded in mystery and perceived bias and almost amounting to a compromise towards the tendering process.
What was your reaction, Makodingo?
You know, when the High Court made the ruling, it was an interesting ruling. They dismissed NASA's contentions, the two, that either Al Ghurair and Jubilee were working in cahoots, that they had canvassed for the tender with the president, and the second, that IEBC had, in all its undertakings, did everything in a manner that biased them towards Al Ghurair, that the tender was predestined to be given to Al Ghurair at the end of it. And when the High Court dismissed that ruling, I expected at that point that they were actually going to dismiss the entire case. Then came the Ekuru Court argument that there wasn't public participation, and it was an interesting argument, especially given our history with procurement. That usually procurement is shrouded in mystery. A biro will be bought by government at 100 shillings when everybody buys it at 20 shillings. So it was an interesting perspective of public participation. The problem is the law, by its nature, by the time you get to direct procurement, you do not expect public participation in direct procurement, because at what point does the public participate? The choice of what method of tender is already predetermined. It has to be direct procurement, because all other methods are already overtaken by time. And then the court took very little time, the High Court, very little time talking about public interest, which should have been the overriding factor. But I think the more important argument the Court of Appeal made today was that the declaration that direct tenders, direct procurement does not require public participation, because by its nature, public participation avenues for it reduce from open tender to the time you get to direct procurement. There really is very little avenue for it. But I think ultimately, it's a win for Kenya. It's not really a win for Jubilee or a loss for NASA. It's a win for the country. We have elections in 16 days. There really wasn't going to be time to do this if the court had disagreed. then chances of us holding an election on August 8th would have been very.
We've had conversations on the political landscape that do we want elections, but we have issues within it, including all these court cases we have. Is it a question of we have to have an election on the 8th, or we have to get things right?
There is an argument that could be made by politicians on either side. We have elections on August 8th. That's a constitutional deadline. It could seem to some people that certain roadblocks have been put on the path of IEBC to ensure that there's no election. Yeah, and you've seen Jubilee make this argument that NASA does not want elections, they are not prepared for it, they want it postponed. And parliamentarians tried this, even in Parliament twice, to amend the constitution to push elections to December, and it failed. I think the idea of a deadline was important. The idea of a timeline was important. The Kenyans agreed. There was a lot of discussion at Bomas on whether to hold elections in December or in August. And by the time we got to August, there was a thought process that went into it. So that everything that then you do must also not be oblivious of the fact that as Kenyans, we decided that elections will be held on the second Tuesday of August.
Nelson, you've said something very important, the perception on that particular contract being awarded to Al Ghurair and the biasness that we've seen, the argument of biasness that we've seen from the opposition. They have supporters. What does this do to the confidence of the IEBC and, in extent, the whole procurement process and contract awarded to Al Ghurair?
The starting point is this: it must always be understood that a decision by a court of law is a decision by man. It may not be entirely correct, but the social contract between man and government demands that man must respect and obey that decision. And often, decisions tend to indicate how erroneous they were with the passage of time. Now, the crux of the issue that fell for determination before the Court of Appeal is, in all practical purposes, the issue of public interest. And they equated the public interest to a wild horse, which if you mount, you don't know whether it will lead you to the lakeshore, to the desert, or to fertile land. And there is no better way of explaining this. And what necessitated the mounting of the public interest horse? It's simply IEBC itself. Because if you interrogate the decision by the Court of Appeal thoroughly, you will come to the conclusion that were it not for the fact that this was a direct procurement, public participation will have otherwise been mandatory. You understand? And what took us to that tangent where direct procurement was resorted to as the only means that IEBC will get a contract with Al Ghurair is because of IEBC itself. It put roadblocks upon roadblocks that will have, if not in existence, enable it undertake an open tendering to the satisfaction of the general public. And you see, publicity is the hallmark of fidelity. Anything done otherwise than through public participation will always invite a lot of concern, will always invite a lot of mystery, and people will tend to fill in the gaps by themselves. So that, in my view, much as this decision will enable us move towards the election with speed, it does not remove the taint that has always been there, that IEBC has been doing something to ensure that we do not have a credible election come the 8th of August.
What would this taint do after we vote and the results go either way, that particular perception that has been left behind, what would it be consequential?
It will be consequential, and this will not be the first time that will be happening. The commissioners that were in office immediately before my friend Chebukati and in this group were actually hounded out of office for almost a similar reason. And even in 2012, 2013, the Public Procurement Review Board, as well as the court, came to a conclusion that, look, we've looked at the contract and the manner in which it was procured by IEBC. It is tainted. It doesn't give confidence to the public that things are okay. But because of the constraints of time, we'll allow it to go. So this will be the second time in Kenya's electoral history post the promulgation of the new constitution, where for all practical purposes the courts and the other adjudicatory bodies are saying, on account of time, will allow a wrong to go. I think if you are to conduct a poll within the Kenyan population, about 50 will agree with the decision of the court, 50 will not agree with the decision of the court. And that is not a good number by all means, irrespective of the judicial decision, which of necessity must be obeyed by all the parties.
According, are you in agreement?
Not really. For one, anyone, I think we have gotten, politically, we've gotten to this point where anyone who does not agree with something will run to the nearest camera and scream impropriety. And in this particular case, this is what NASA did. Now, NASA have probably had some legitimate grounds for taking IEBC to court previously. On this one, they didn't. I mean, the two courts have, in so many words, said so, that they went to court with newspaper cuttings, that the fact that there was an Al Ghurair, a person called Al Ghurair, that led a Dubai Chamber of Commerce to State House for purely official business, cannot possibly mean that that company is bad, that they're doing business with Jubilee. I think we need to get out of this rut we find ourselves in as a country, where anyone shouting wrong is taken seriously. Yeah, because then if you do that, nothing can actually move forward. Yeah, NASA or whatever, or Jubilee will always come up and say IEBC doing something wrong, they're doing something improper, and if you take it on the face of it, then IEBC will never do anything right. And the court made, in my opinion, some very significant rulings. That one, you cannot hold IEBC responsible for having gone through a court process, lost, and started another process. Because you remember the tendering process began in August last year. It was an open tender. It was then, it went through, and an award was given to Al Ghurair. The process was taken to court by the loser, and the tender was cancelled. IEBC then attempted a restricted tender, where Al Ghurair again won. The tender documents were apparently, for some reason, they were messed up. Where they got themselves is not because they wanted to. I mean, I don't think someone was sitting at IEBC, and that is a determination the court made, was sitting at IEBC saying, let's mess this up deliberately so that we end up giving this thing to Al Ghurair. And NASA made the argument in court, but did not provide any evidence to actually support it. And the court in its ruling said that we do not find any foundation and any grounds for any of those claims. But more importantly, the court said where IEBC had gotten to, the only method they had available was direct procurement. And in direct procurement, the court held, it did not say because of public interest, it's okay, no public participation. The court held that in direct procurement, according to sections 103 and 104 of the Public Procurement and Disposals Act, no public participation is necessary, because it meets the whole purpose of direct procurement to begin with. So where we are legally, where we are, and Nelson will tell you, we are safe. Of course, perception-wise, I think NASA got what they intended. I don't think, even in the first instance, they actually expected to win. Yeah, the way a lot of lawyers didn't, I don't think NASA expected to win. NASA has been doing a build-up.
So you think it was a game of perception?
No, it was a game of perception. Over time, all their 34 plus cases have been designed to ensure that they are set up proper ground for rejecting whatever outcome doesn't favor Raila.
What would that do to this country?
And that is the problem. We are a fragile country. We remember what happened in 2007, 2008. Now, we cannot say, we cannot then say that, oh, because we fought, we should do things wrongly, so that then, but politicians also should precipitate scenarios and situations that ultimately lead to a 2007-2008 scenario without any
really,
evidence
as you say that NASA was setting up perception games on the masses, IEBC has constantly said sometimes it has appealed these cases because they needed clarification. Shouldn't we assume that is the same thing NASA needed, clarification on a number of things?
But NASA went to court with no evidence. Listen, when NASA took the case to court about returning officers being final arbiters, announcing final results, they had a case. And the court agreed with them. And IEBC said we appealed because we wanted a clarification on this issue. And the court made a clarification. And everybody accepted it. But on this one, there are no evidence.
I would like you to react to what he says. Was it a game of perception for NASA?
Akisa, in law, there are two phenomena that are often used by the judges to get out of a difficult situation. One is called overtaken by events. And the fact that your claim has been overtaken by events does not necessarily mean that you did not have a claim in the initial instance. So that to the extent that an argument will be put forth that IEBC cannot be blamed for the eventuality that has befallen us now, I think it's a very pedantic argument, because if that be the case to espouse, then it can also be said NASA was equally entitled to go and seek clarification. But you see, NASA, in my honest view, and I do not hold brief for them in any way whatsoever, is a litigant. It's a participant in the electoral process.
Okay.
The person who has the oversight of this role as the referee is IEBC.
All right.
IEBC has the overall mandate of ensuring that things are done in a proper way.
Okay.
And this is no longer in the realm of conjecture. We have seen time without number, the numerous mistakes that they have made that have occasioned scenarios of this kind. So that the perception that things are not right will continue being there. And lastly,
look, if we are out of time, just
if something is said to be mysterious, it's just mysterious. What other evidence would there have been of what is claimed to have been that incestuous relationship?
Okay, Nelson. Thank you very much. We'll have to end it on that note. This is a conversation we'll continue to having. It's a wide one. We cannot accommodate it in one space. But we wrap Worldview at this point. Thank you very much. Nelson Harvey is a lawyer, Washington Makodingo, governance expert, political analyst. We'll definitely continue with this conversation, even online. My name is Akisa Wandera. I leave you with the country folks. But remember, President Uhuru Kenyatta and his deputy William Ruto are at the burial of a former minister, Nicholas Biwott. Once they start addressing mourners, we'll definitely be going there live. Enjoy the rest of your evening.